Buongiorno, hello to everybody. My name is Nicola Canestrini, an Italian defense attorney and owner of the Canestrini Lex law firm and the website canestrinilex.com. My main field of practice are Italian and European criminal law and Italian criminal defense. Actually, I'm president of the Regional Italian Criminal Lawyer Association of Trento. Today, I'm gonna speak to you about the use of modern technology in Italian criminal proceedings. First of all, I give you a short introduction about the Italian criminal system. Then, I'll try to point out possible benefits of use of modern technology in criminal proceedings, trying to get a special focus on trial by video conference. Then, I'll try to set out some risks of such a use. I will finish with a short link to the topic of mass communication technology and its impact on criminal proceedings. So, let's go on. The Italian legal system is that of a civil law state governed by codified law. The first and initial code in the Italian Republic was established by the fascist government in 1930 and was kept until 1988. This code adopted an inquisitorial system. In 1988, a new code was enacted. This chose to abandon the inquisitorial system, but did not go so far as to represent a complete transition to an adversarial one. The resulting system could be considered to be somewhere in between the two, although it is closer to being an adversarial system. The legal culture and the Italian law in action in fact demonstrate, in my point of view, an inquisitorial approach to fact-finding. As the Constitutional Court has stated, the last sense of criminal proceeding is the search for the truth. Since 1989, the trial is supposed to be party-dominated and strictly separated from the pre-trial process, it is the investigations. It is the parties who present lists of evidence to be taken, and it is they who examine and cross-examine witnesses. But, and that's the reason because I speak about an inquisitorial approach, the judge can strike manifestly superfluous witnesses from the list, reject irrelevant lines of questioning, ask witnesses and experts, and can even, if absolutely necessary, order additional evidence to be taken. The supposed strict separation between pre-trial investigations and trial proceedings has not survived the very first years after the reform of Italian criminal process. The law and the jurisprudence of the courts have since permitted the introduction of pre-trial statements under more and more liberal rules. If the judge of the trial is convinced beyond all reasonable doubt the defendant is guilty, the judge must convict him. If not, the judge must acquit. The judge must also publish written explanation of his decisions. It is important to note that Italy does not try anybody by a jury of peers. The sentence is written and the verdict is decided by the judge himself. Serious offences have a three-headed court of judges or a two-headed court of judges and 6 jurors for the most important crimes. The parties can appeal against the sentence before the Court of Appeal, which rules again on the merits, usually without gathering any other evidence. And then the parties can appeal a last time before the High Court, the Corte di Cassazione, before decision becomes final. Of course, technology offers endless new universes of possibilities for offenders, but technology enables to improve efficiency of the criminal trial and law enforcement. So, technology changes everything, trial included. There are some benefits and some risks. Concerning benefits, we could figure out at least 4 of them. Better internal efficiency. We would need it because 2012 there were approximately 4.7 million pending criminal cases in Italy. Technology could even help for law enforcement. Let's think about house arrests, pre-trial measure with electronic bracelet monitoring. Regarding the electronic bracelet, I have to tell you that since 2001, over 9 million euros were spent by Italian government for those electronic bracelets. Until 2013, only 15 bracelets were in use. Even if now something is moving on, a Bulgari bracelet for offenders would have been less expensive. The benefits of technology could even help for realization of fair trial. In Italy, for example, there is always the exact record of the court hearings, and the records are transcribed by the court, and the parties can use the transcriptions for their appeals. The fair trial could have a benefit in using modern technology even for forensic evidences, as you may know. But we could use, and Italy uses modern technology even for witness protection, for example, in organized crime trials. In this regard, I would like to speak about the trial via video conference. Italy introduced the trial via video conferences in 1998, but only in following cases. For organized crime trials, let's think about drug trafficking or mafia trials. There are usually trials of hundreds of defendants with many ongoing trials, and the need to have defendants to be carried from one trial to the other. And let's think about the risk of contact between the defendants in mafia trials. Beside the organized crime trials, trial by video conferences is foreseen by Italian procedural law for terrorism trials. But there could be, in these two cases, the use of video conference only for security reasons or for very complex trials. Same method could be used even for so-called cooperating witnesses. The Italian Constitutional Court stated that there is no matter of fundamental rights violation with its decision 342 of 1999. But in my point of view, there could be still a risk for fair trial. Let's think about the Zagaria case before the European Court of Human Rights. The application was 58295 of 2000. The case concerned that Mr. Zagaria, an Italian national, complained that it was impossible for him to communicate confidentially with his lawyer because his communications, or their communications, during the video conference trial were wiretapped by police. The European Court of Human Rights held unanimously that there had been a violation of Article 6, 1 and 3c, so the right of a fair hearing. Of course, confidentiality should be guaranteed using the technology in the trials to realize the fair trial. Quoting Professor Garrett in his book Convicting the Innocent, Where Criminal Prosecutions Go Wrong, the two most common types of evidence supporting innocence convictions are suggestive on unreliable eyewitnesses' identifications and invalid or vague forensics. In criminal cases, the presentation of forensic science is almost one-sided. Of course, there is a big difference in use of forensics by the prosecutor or by the defense. There could be some problems if the defendant has no economic chance to hire the best experts he could use. As I quoted, junk science could send to prison, but real science can even prove the innocence, if there are the chances, the economic chances to do so. There is another one and the last point I would like to figure out. There could be a conflicting interest protected by Article 6, 8 and T of the Convention and 10 of the Convention for the Protection of Human Rights and Fundamental Freedoms, and the necessity to balance these rights in view of the facts of every individual case. So we could think about the fact that the freedom of expression and information should face the presumption and could conflict with the presumption of innocence, the right to fair trial, and the respect for private and family life, as stated in the European Convention for Human Rights. It has been stated that in the context of criminal proceedings, particularly those involving juries or lay judges, judicial authorities and police services should abstain from publicly providing information which bears a risk of substantial prejudice to the fairness of the proceedings. The stating is taken from the recommendation of the European Committee of Ministers of 2003. So thank you for your attention. I hope you appreciated my introduction about the use of modern technology in criminal proceedings under Italian law. If so, I will be glad if you visit the English section of my website, canestrinilex.com, or join my LinkedIn network. Arrivederci.